I defend a lot of cases that are brought by other plaintiffs' lawyers. So I get to see what they do and how they go about doing it. And I'm going to give you a list and some examples of the mistakes that I see being made routinely. And I take advantage of these when I'm defending cases. And I make really sure that when I'm prosecuting a case on behalf of a plaintiff, I don't commit these mistakes. The two biggest mistakes I see: not being familiar with the medical records and the documents in the case, and not prepping a client. So let's talk about being familiar with the records. In any personal injury case, there's going to be dozens, if not hundreds, and possibly thousands of pages of medical records. Somebody's got to sit down. Somebody's got to sit down and read each and every record. They have to know what's in those records. Because I'll guarantee you, on the defense side, the attorneys and the paralegals are going through those records. They get paid to do it. They get paid to go through those records by the hour. They read them and they create outlines about those records. They create indexes. It's a big part of the practice, is just making sure you know every single thing in those medical records. It's important for a plaintiff to understand what's in their medical records, because if they have no idea, when we sit down at a deposition, it's not going to go their way. I am going to know so much more about the case than they do that I'm really going to be able to take advantage of it. They're going to say things they should not say. They're going to take positions they should not take. Whether they're doing it on purpose to lie to me or just mistaken, I don't know. I'm not going to sit here and call somebody a liar, but it sure comes across that way if you don't know your own medical history. So plaintiff's lawyers, spend some time, earn your fee, read the medical records. Next step, make sure your client knows what's in those medical records. Prep your client. I sat down in a deposition, I can tell within 30 seconds if the client has been prepared. My client, when they sit down, they're going to give you yes, no, I don't know, I don't remember. Those are the 4 answers they're going to give you. They're going to answer your question truthfully, but that's all they're going to say. If a question involves something that they have to explain, it's going to be a short explanation. They're not going to ramble off about what they did last Tuesday or what they think they did last Wednesday or what they had to eat a week before. They're going to stick to the point, because the more they talk, the more trouble they're in. It's lawyering 101. I am seeing plaintiffs' lawyers routinely who just hold their client's hand, sit down next to them, and lead them to the slaughter. They're not prepped at all. They have no idea what a deposition's for. They have no idea what we're there to talk about. They have no idea what's in their medical records. Prep your clients, because you're not earning your fee if you don't prep your clients. Some other mistakes I'm seeing from personal injury lawyers is this: they don't screen their cases. We did a video a couple weeks ago, maybe a month ago, about lawyers who just take anything that walks in the door. Well, that's what they're doing. They're taking anything that walks in the door, and they think filing a lawsuit is some magic bullet that makes the case worth more. Filing a lawsuit does not increase the value of a case. If anything, all filing a lawsuit does is give me access to things I wouldn't otherwise have to devalue your case. So it gets back to personal injury lawyers doing their job, reading the records, understanding the case, so that they can make an educated decision as to whether or not they're actually going to file a lawsuit to give the defense access to all these things. Screen your cases. Know your case. Next thing they're doing is they're setting unrealistic expectations. And heck, I'm guilty of it too. You're not going to find very many lawyers' websites or very many advertisements out there that don't at some point say, hey, we did this for Miss Smith. We did this for Mr. John. We got him all this money. Well, that sets an expectation. If it's not controlled, that sets an expectation that this firm gets those kind of results. But each case stands on its own 2 feet. Every case is different, and I have a conversation with every single client that walks in my door about what I believe to be the reasonable expectation. Every case is not a $1 million case. Every case is not a $100,000 case. Every case is not a $25,000 case. You need to have that conversation up front so that when you get to the point where you're settling, or you find yourself at mediation, or when you get an adverse judgment, your client knows, their client has been informed about what to expect. You can't just sit back and be scared that if you tell your client the truth, they're going to leave you. If you can't tell your client the truth, they need to leave you. They need to go somewhere else. So set realistic expectations. It's better for everybody. It lets the client move on if they want to. It keeps a case from dragging on for years and years with a client thinking they're going to get this huge payday only to be let down at the last minute. Set the expectation up front. Do your job. Do the job up front so that it doesn't have to linger on for a couple years.